qualification for folks. And a lot of times I forget to say that, so that's why I want to say it up front. So if there's something that piques your interest for either you or for a family member here today, we'd be happy to talk with you about it in our office and get some questions answered for you. But today we're going to talk about three main topics. The first would be legal documents, making sure your affairs are in order and things can be handled for you in case you cannot handle them for yourself down the road. We're going to talk about Medicaid, which is one of the ways that a nursing home in Kentucky may get paid for. And then we're going to talk about veterans benefits. Happy Veterans Day. Thank you. If there are veterans in the audience, thank you so much for your service. The military is very important to Misty and me in particular. Both of our fathers are 100% disabled veterans. I just lost my father this summer, and he did receive VA benefits. So we have, in addition to our professional experience with these types of things, we also certainly have these personal experiences. So let me just jump in. If you do have questions as you go along, I know you're eating, so it may not be very convenient for you to ask the questions, but if you do, please feel free. What you're thinking, someone else might be thinking as well, so we want to get that answered. And then Misty and I will have some time afterwards if you want to talk to us individually. Okay, so what legal documents are needed? That's our first topic. These are basic foundational legal documents. We're not going to go into complicated trusts, so that's also a legal document, but it's not something that you absolutely have to have, generally speaking. These others, we would say, you really do need them to make sure that your wishes are honored, they're made known, and what you want done can be done. So the first one would be a durable power of attorney. It's a financial document for someone to handle your assets. Then you would also need a healthcare surrogate, someone to make healthcare decisions for you if you cannot. Also a living will, your end-of-life decisions, and then finally a will where your things would go when you pass away. Durable power of attorney. Power of attorney means you are allowing someone else to act on your own behalf. Someone can handle your finances for you, pay your bills. Sorry, my P's and my B's are going to be bad. Pay your bills, or sell your real estate, or buy something on your behalf. Anything to do with assets. What that person can do on your behalf will depend on what your document says that they can do. So we see a lot of documents and they say, well, this person's my power of attorney and they can do anything that I can do. That doesn't cut it anymore. It used to, but anymore, if you want your power of attorney to have banking powers, you need to list banking powers. What can they do? Our power of attorney document is 9 pages long, just to give you a sense of how detailed we're talking about here. Someone needs to deal with insurance, we've got a paragraph in there dealing with insurance, right? If you already have a power of attorney document, I would encourage you to take it out, take a look, see does it have those details in it. Have you named one person to act on your behalf, and then also named an alternate in case that first person can't act for you. If you haven't, it's just like you don't have a power of attorney if that first person is no longer able to act on your behalf. So you really want to put in alternate names. Sometimes people will say, well, I'm going to name every single child successively, one right after the other, and you can do that. You can have as many alternates as you want. We do discourage you from having more than one person serve at a time, even if we say that only one of them has to act. The bank can require all of them to act, or both of them to act. So it doesn't always happen that way, but it certainly has happened in enough cases to where we encourage people to only have one person serving at a time. Durable means that it goes into effect when you sign it, and then it's going to stay in effect even if you lose capacity to make your decisions in the future, which is exactly when you want it to be in effect, all right? So if it doesn't have the durability language that the statutes say it needs to have, then right when you need it to be used, it's not going to be effective. So make sure if you have one that it has that durability language. Some people have a springing power of attorney, some people have an immediate. We prefer the immediate. Immediate means as soon as you sign it, you're giving that person the ability to handle your affairs. It goes into effect immediately. Springing means it springs into effect at some point in the future. It sounds great. We would all like for someone not to be handling our affairs until we lose the capacity to do that. However, it takes at least one, maybe two, doctors to sign off and say that you don't have the capacity to act on your own behalf. Those doctors usually will not do that, so then this power of attorney document never is able to be used and we end up in guardianship court. Right? So a power of attorney, if you have one and you didn't record The person you appoint as the power of attorney, they're called the attorney-in-fact. They cannot handle your real estate unless it's part of the chain of title in the deed room, so that's why you want that to be filed. Any questions on power of attorney? Yes, sir.
What about spousal rights? We just had, my wife and I had a simple power of attorney for each other.
Yeah.
And everything we have always joint.
Yeah.
How does spousal rights?
Okay. So the question is how spousal rights affected, and they have a simple power of attorney naming each other. I'm so glad we have a simple power of attorney naming each other. Most of the time, we see married couples, they think they don't need a power of attorney. And when we do a longer presentation, we actually spend a lot of time talking about that. Spouses do need powers of attorney for each other. Even if you have your assets held jointly, they may not necessarily be joint with right of survivorship, to where one of you can act on behalf of the other. You might be what's called co-tenants, and so each of you has to act on your own behalf, so you need a power of attorney for that. But think about an insurance policy that you have. Who's the owner of that policy? You are, one individual. Think about an IRA. That stands for Individual Retirement Account. Only the person who owns that account can do anything with that. Make a withdrawal, make a contribution, find out who the beneficiary is, talk to the company, right? So spouses do need those powers of attorney, and we want you to have a good, strong one to make sure that if you can't speak for yourself in the future, your spouse will definitely be able to. Just by law, your spouse does not have the right to handle your finances. You have to have that power of attorney document. Okay? So healthcare surrogate would be the second document. We think of this as a medical power of attorney, and sometimes it's called that. So instead of who can handle finances for you, it's who can handle your healthcare decisions. Now, unlike the power of attorney, it does not go into effect immediately when you sign it. It's only effective if you cannot make your healthcare decisions yourself. As long as you can, you do, and the doctor listens to you. So I have had many times, I've had mother and daughter come into the office, and the daughter says, "There's my healthcare surrogate. Mom has leukemia, and she's refusing chemo. I say she needs chemo, tell her she has to have chemo." And I say, no. Now, you do not have the right to trump your mother's decision. As long as that person is still capable of making decisions, what she says goes. Right? This healthcare surrogate is not about your end of life. That's the living will, we're going to talk about that. This healthcare surrogate is about all those times during your life that you need someone to act on your behalf. So you fall and you're unconscious, and you need someone to tell the doctor it's okay to do surgery or to give you this treatment or medication. That's what this healthcare surrogate is about. We want you to have HIPAA language in it, just to make sure they can get your records and talk to your doctors, name one person, name an alternate. Okay? Next. Guardianship is what happens without the documents. It's a court process. In Kentucky, it's a jury trial. If you can't handle your own affairs and you haven't appointed someone to do that for you, someone has to file for guardianship to become guardian over you. It takes away all your rights. It's not a place we want to be. That's why having these good legal documents in place is important. It can take months to get a guardianship in place. What happens in the meantime when you're needing all those decisions made for us? Not a good situation. Living will, end of life decisions. Make them for yourself, please. Do not burden your family with having to decide whether you wanted life supports or not. And when you make your decisions, please talk about them with your family members. Please let them know what it is that you want done. And they don't have to agree with it, but they do have to understand that they need to abide by it. Tell them why you made those decisions. So if you're in Kentucky, you want the Kentucky Living Will. There's actually a format that needs to be followed. It has an introductory paragraph that says, "I'm at the end of my life, here are my wishes." And then it says, "I want life supports, I don't want life supports, I want a feeding tube, I don't want a feeding tube." If only the language were actually that clear. That's what the language means, but you may not understand that when you read that. But there are little dashes out to the side, and that's where you initial. Whatever is your decision, that's fine. Just make sure you put your wishes down on paper. It will also ask if you want to donate your body to science, which you could do with U of L. You can fill out their paperwork as well. Or if you want to donate organs or tissues to help the living when you pass away. So again, you get to make those decisions. It's a document that has to be notarized, and then that can be put in force. So we usually have a slide that says a living will is not a DNR, and what the difference is. It says that at the very bottom, so let me just address that. Everyone comes into my office saying, I want a DNR. Everyone leaves saying, I don't want a DNR, right? A DNR is do not resuscitate. So that means if your heart stops, you don't want them to restart it. You don't want them to do CPR, you don't want them to get out the pads, okay? I have a 7-year-old daughter. If I stop breathing, I want each and every one of you to try to resuscitate me. I don't care what your training is, right? Bring me back. But I have a living will. So that's on the other side of the coin. I'm about to die. Do I want to die naturally? Do I want my life extended artificially? So if you would not have a quality of life, if you were to be resuscitated, that's when we say it's time for a DNR. My father had heart failure. We put a DNR in place. Another heart episode just would have diminished his quality of life entirely. So that's the difference between those two documents. Any questions on a healthcare surrogate or living will?
Yes, if you don't have a healthcare surrogate and you are in an accident or something, what happens then?
If you don't have a healthcare surrogate and you need someone to make decisions, what happens? There is a statutory protocol. So it says if you had a guardian put in place and if the court's order said that guardian can make healthcare decisions, that's the first person the doctor is supposed to look to make your decisions. If you don't have a guardian, they're supposed to look to a power of attorney if your power of attorney document contains healthcare language. Next, they would look to the spouse. So yes, you could have your child named as power of attorney and your child is who the doctor should be listening to rather than your spouse. Okay? Does it happen that way in real life? Not necessarily. We were just discussing that as a matter of fact. The doctors kind of do what the doctors want to do. So if they have families who are feuding in their waiting room, we don't know. Maybe they're going to talk to their administrators. Maybe they're just going to say, people decide this and let me know what the decision is. After that, it would be children, and then it would be parents, and then it would be next living relatives. So there is a protocol for healthcare decisions, not for financial decisions. Anything else on that? Yes, ma'am.
Are physicians bound to follow the rule instructions in the living will?
Are physicians bound by law to follow your instructions in the living will? Yes, they are. They are bound to follow your instructions unless they have a religious or moral objection to it. We will see sometimes at religious affiliated hospitals that there are some issues there. Now, do they recognize that they're bound by law? And do they follow the law all the time? No. They really don't. So we were just discussing what do we need to do to educate them, and we do speak to the doctor groups frequently, actually, to let them know. So you may have to get an attorney involved at that point if the doctor is not following those instructions. Anything else on that?
Should you file your healthcare surrogate or living will with the hospital? Like, should you give them a copy?
That's a great question. So what we recommend is that you give the hospital, every treating physician you have, your specialist, whatever, a copy of your healthcare surrogate. And when we do a healthcare surrogate, what we do is put that person's name and their phone number, because it's going to be an emergency when they need to be reached, okay? So we want that on file. We want them to know who can make these decisions. Your living will, however, we say don't file that until someone's at an end-of-life decision. Until that time, the healthcare surrogate gets to make those decisions. And with the living will, what we have seen is that it can affect people's care. It shouldn't. It should be about the end of life. I'll again use my father as an example. He was in the hospital. He was considering a heart procedure that would have inserted a pump that would make his heart for him, but he would have to be on a ventilator for that. They had a copy of his living will. They thought they actually did, but they had put in their records that they did, and they had assumed that meant that he did not want to be on a ventilator. And so the nurse that we were talking to said, well, you could never have this surgery because you don't want a ventilator. No, it's not about if you could ever have a ventilator or ever have a ventilator.
If you remarry later in life,
Yes.
and you already had a will before your remarriage, is it still good, or do you have to redo your will?
If you get remarried, you want to redo your will. As spouses, we automatically are entitled to part of our spouse's estate, all right? So if you don't want your spouse to have as much as, if you don't want your spouse to have everything, don't write a will at all, they'll only get half, right, in Kentucky. If you want them to have everything, you need to say in your will that they can have everything, right?
two people on that account with the bank as a beneficiary?
That's going to be up to the bank itself, but usually, yes, you can. What you can't do on that type of beneficiary designation is say to my daughter, and then if she's died, to her daughter, which you can do with a will. So I don't want to give you a false sense of this is definitely the way to go. It could really upset your estate plan, and things might not go where you want. And it would definitely be something you would want to review as things change in your family. Anything else? Yes, ma'am.
How many advantages and disadvantages to, like, an adult child getting on the fifth account before something?
Yeah, advantages and disadvantages to having a child on the bank account. There are things in both columns, that's true. The advantages, it doesn't actually pass to them when you pass away, and they don't have to have that death certificate if it's a joint owner situation. So that's an advantage. It also allows them, if they're a joint owner, it allows them to sign checks. It's also a disadvantage, because they can sign a check, and it has nothing to do with you or your care. They could use it for themselves. If their name is on it, it's subject to their creditors. If they get in an accident and they're at fault or claim to be at fault, they can come after that money. Questions about those? Okay, so Medicaid, introduction, and then Misty is going to come up here in just a minute. So we can see here that private pay is about a third of people and Medicaid is about 2/3 of people. Go ahead. People getting paid for their care in the nursing home. Medicaid has financial requirements, and they're different depending on whether you're single or you're married with a community spouse. Single means you've never been married, you're widowed, or you're divorced, or both spouses are in the nursing home. Medicaid treats both of them as being single. Married with a community spouse means that there's one spouse in the nursing home and one spouse is not in the nursing home. There's a spouse living in the community. Medicaid does not want to totally impoverish that spouse, so they will let them keep part of the assets, and we're going to look at what that looks like. Some of the assets, Medicaid calls them resources, but they're assets. Some of them are exempt and some of them count, all right? So here's what Medicaid does. Medicaid takes all of the assets from either spouse or both spouses. Doesn't matter if it's the husband in the nursing home and it's the wife who's at home and it's only her name on that bank account. It still counts against that husband. Right? Doesn't matter if she inherited it, never put it in his name. All assets of both spouses count against both. What happens is the person who's in the nursing home, they pay their income to the nursing home, and then Medicaid pays the nursing home the difference if someone's on Medicaid. All right, so what assets are exempt? We have that a Medicaid compliant funeral for each spouse is also exempt. And then we'll go to the resource. Let's go ahead and go to the next one. We'll go to the resource assessment. So what happens is Medicaid adds all of these things up, takes out those things that are exempt, the house, the vehicle, the funeral, IRAs. What's left, Medicaid cuts in half. Everybody got that? The spouse who's not in the nursing home gets to keep half of those assets, but there's a cap on that. They cannot keep more than $119,220. That's the figure this year. So cut it in half. Spouse keeps half up to a maximum of $119,220. The person in the nursing home always gets to keep $2,000, and that's it. All right? What's left has to go through what's called the spend down process. You heard of spend down? That means spend it on the spouse in the nursing home, not necessarily to the nursing home, but on the spouse in the nursing home or the community spouse. Right? So we're going to take an example here. It says resource assessment. When we have a couple, the first visit to Medicaid is not for an application, it's for a resource assessment where they're going to take that pie, cut it in half, tell the spouse how much they get to keep. It's called the resource assessment. They have a home, it's $150,000. If it were $450,000, it would still be in that exempt column. IRA, $35,000. If it were $350,000, it would still be in that exempt column. Vehicle 1, $15,000. If it were $55,000, it would still be there. Second vehicle, we couldn't get exempted, nor the savings or the CDs. Cash surrender value of the life insurance policies. Been paying on a whole life policy for 30 years? You could cash it in for a certain amount now that may be less than the death benefit. Well, whatever you could cash it in for, Medicaid says, cash it in. Spend it on your care, so that counts. They have a lake property, good for them, not for long, all right? That's worth $110,000, so you add all that up, it's $180,000. Cut it in half, The spouse at home gets to keep $90,000, the nursing home resident keeps $2,000, and we have to spend down $88,000. Very commonly, what we do in this case is sell the $150,000 home, take that plus the $88,000 that has to be spent down, buy a newer, nicer, safer patio home where the spouse at home can age in place, we hope, and we're prepared for Medicaid just as soon as that's done, so we can quickly get them qualified. All right, Misty. Yes.
Some squeaky maybe here.
Yes.
Are the laws the same?
The laws are not exactly the same. Medicaid is a federal and state program. So there are federal overarching statutes and regulations, but each state gets to put their own spin on it. These rules in particular, where we're looking at half of the assets and $119,000, that is the same in Indiana. IRAs are not exempt in Indiana. The IRAs of the spouse at home are, but the IRAs of the spouse in the nursing home are not.
I want to ask about term life. Would that automatically go to the nursing home on F-CHAP?
Okay, so term life insurance has no cash surrender value, so you're not required to cash it out in order to become eligible for Medicaid to pay for the nursing home. The risk with term life is you want to make sure that you designate a beneficiary that is not your estate. As long as you do that, then there will be no recovery. Medicaid does have a program called Medicaid Estate Recovery. They will come back and haunt you if you don't plan appropriately. So somebody who's on Medicaid receives $50,000 worth of benefits. As long as their term insurance pays their daughter and not their estate, will be fine. If their term insurance pays their estate, Medicaid will say, we'd like our $20,000 back, please, because we can recover from your estate. So it's important to make sure in our wills, in our legal documents, that we're also addressing any issues that might be out there regarding Medicaid paybacks later on. And we can address most of those as long as we're proactive about it. With Medicaid, I think it is really important to understand, people hear a lot about Medicaid in the news. That is not the part of Medicaid that we are talking about. When you hear about Medicaid in the news, you're hearing about what's called Obamacare, the Affordable Care Act. That is an expansion of the Medicaid program that pays for low-income disabled individuals health insurance or working people who can get subsidies to help pay for insurance. This program is old in the sense that it's older than me, and it pays for the nursing home. And you can tell how old it is because it pays for two things: a little bit of home care, never enough, and the nursing home. There is no assisted living benefits through Medicaid in Kentucky. In Indiana, there is, but we've heard it's like a unicorn that you may or may not find. And then there's no personal care. You know, you hear about memory care, unskilled memory care. That is not going to be paid for by Medicaid. It is for the big ticket items. And let me tell you, nursing homes are big ticket items, averaging $8,500 a month to pay for skilled care in Kentucky. And if you want to, you can certainly pay $11,000 a month in this area. So it's an important program. Even people who work hard, save their money, do everything right, can deplete all of their assets. And this is why Medicaid exists. It's why over 60% of people in nursing homes, Medicaid is paying the bill. It's really important to understand their rules, though, because it may not be there when you need it if you make some bad decisions that you don't even know are bad decisions. And that's because of this rule. You may hear the term 5-year look back. I heard that Medicaid has a 5-year look back. What that means is, from the time that you go to Medicaid and say, please Medicaid, pay for my nursing home and my spouse's nursing home, they are going to look back 5 years to see what transfers you have made for less than fair market value. So what have you given away? You gave Timmy some money because you love Timmy, he's a good son. You're going to get a penalty. You loaned Timmy some money, Timmy's never paid you back, never going to pay you back. You just committed a transfer, you will have a penalty. You wanted to pay for your grandchildren's education, you love those guys. You're in great health right now, don't know you're going to have a stroke 3 years from now. You are going to have a penalty. And I think we'll even see on our next slide there, Kelly, one that we see unfortunately a lot is you decide, I'm going to add my daughter's name to the deed on my house because I don't want it to go through probate because I'm a little scared of probate. You have committed a transfer of half of your property value and you don't know it and you will have a penalty. Or you sell your house and it turns out you've got some shag carpet, some wood paneling, hasn't been updated, the appliances are avocado green, you've got an incontinent dog. It's not going to bring what the tax guy said it's going to bring. Medicaid says, well, we think you gave something away because Tony Lindauer said it was worth $120 and you sold it for $99. And they will penalize you. And it's harsh. For every approximately $6,000 that was given away, Medicaid will not pay for the nursing home for 1 month. And you don't have money anymore because you have to be broke before this penalty period begins. So you have to be compliant with the rules. So while we'd like to spend a lot of time planning ahead and helping families make sure everything is going to be done correctly and that we're going to be in a good position, we find ourselves many times fixing problems that have developed because we just didn't know the rules and they are difficult to find. So Medicaid is a great program that we can use to help pay for our care, but it has a lot of regulations that are constantly changing. As Elderlaw attorneys, what we're looking to do is try to help families maximize the benefits, get them sooner rather than later, be able to make sure there's plenty of money there to take care of the person in the institution or in the facility, plenty of money for the community spouse who may live many years thereafter and have care needs of their own. Many times people have disabled or dependent children that have they taken care of forever. And to be honest, most people don't want to have lived this life and worked as hard as they did to die. And we help try to make that possible if we can, and to make sure they get the kind of care they would like in the kind of aging progression that they want to help. If they want to age in place, we try to make that happen as much as we possibly can while maximizing benefits. So I told you Medicaid doesn't cover assisted living. Medicaid is not going to help us with home care. They claim that, I promise you, it is a unicorn. This is a benefit that many people do not know about that can fill those gaps. So this is called a VA pension benefit. It is not a pension like I worked at Ford for 20 years and I draw a pension. It is not that. It is not retirement. It is an amount of money that a veteran or their surviving spouse can receive every month by direct deposit to help pay for care if they satisfy service requirements and there are income asset requirements. So there are 3 different types or 3 different levels. The one that you may hear talk about at times is what's called aid and attendance. So this is this last column on our chart here. These money amounts are not insignificant. Kelly's much shorter than that. These amounts are not insignificant. So for a veteran loan, they could draw another over $1,700, almost $1,800 a month. Or for a veteran and their spouse, over $2,100 a month they could draw from the VA to help pay for care. This is significant for people who need to pay for Atria, or they need to pay for Homestead to come in, or Bright Star to come in and take care of them. So what are the service requirements? It is not what you would expect. You do have to be over 65, so that is one requirement. But you have to have served during a wartime period. So you have to serve 90 days of consecutive active duty, so not in the reserves, active duty. 1 day has to fall during a designated wartime period. You could have served all of that in Fort Knox. Doesn't matter. You do not have to have been, storming the beaches of Okinawa. You could be in Fort Knox the whole time. And you obviously have to have a discharge that was not dishonorable. Medical, general, any of those will work. Many people don't realize when our designated wartime periods are. And they may think it's, World War II ended in 45, right? No, it ended at the end of 46. So a little bit longer. Vietnam has multiple time frames, because this may shock you all, but we may have been there a little bit earlier than we said we were at one point in time. And you may not know that we are in a designated wartime period right now. And we've been in it since 1990. So we were actually in the longest designated wartime period of our country's history. It will end someday by presidential proclamation. For the VA benefit, you have to qualify with income and assets. And unlike Medicaid, who gives us these crazy but very precise numbers, 119,220 or at least 23,844, VA says we're going to use a balancing test. And we're going to balance your life expectancy with your need, with what you have coming in. I don't know, a couple things we're going to find here and there. As practitioners in the Elderlaw, I guess you can't say specialty, Elderlaw focus, we know kind of where they slice the bread. For a couple, you need to have about 80,000 or less in resources or assets. They do not exempt out IRAs. And for a single individual, you need to have around 40 or less, and we like to see it more around 20. There are things that are exempt still. The home is still exempt, vehicle is still exempt. Those things still don't count while we are looking at this benefit. One of the issues is income, and income is even harder to explain. But income for them, they want to see that you are using almost all of your income on your unreimbursed medical expenses. It's real easy to figure this out when someone's in assisted living. They get $2,500 of income every month. They're spending $4,000 on their assisted living home. They have a negative income for VA. If they got $2,000 in income and they're spending $1,500 a month on their home care, they have $500 in income for VA. How much their income is determines how much they get of that number that was in the bottom of our chart. If their income for VA is 0 or in the negatives, they're going to get the whole thing. If it's 500, they're not going to get the whole thing, they're going to get a portion of it. So that's how VA figures out income. The interesting thing about VA right now is there is no look-back period. So you know when we talked about you transfer assets away with Medicaid, they say, that's fine, but you're going to have a penalty period. VA is not that way right now. So I can do transfers on a Tuesday and get VA on a Wednesday. And there is no penalty for that. That is going to change. So the VA is going to move to a system that is somewhat similar to Medicaid. Their look-back period will be shorter. The proposed look-back period would be shorter, 3 years. But they would have numbers now that are fixed. So we wouldn't be doing this balancing test anymore. It would be, the numbers they had proposed actually were the Medicaid numbers. So they were going to try to keep it very consistent. So the big tool, and Kelly kind of touched on this, that we use many times for both Medicaid and VA, because we're often planning with the family for both benefits, is this irrevocable trust document. So many times we will use one of those. It is a transfer for less than fair market value. So ideally we're doing this more than 5 years in advance. That's our ideal situation. But sometimes it's not possible. There are a lot of tools that we have and we use for what's also called crisis planning. Crisis planning means I don't have 5 years. I may have -1 day. So there are oftentimes, Kelly and I, the person comes in and sits down and says, Mom went or my wife went in a nursing home last Friday. But there's no 5 years there. It's important for families to know, though, that it's not, and never is, a hopeless situation. With the help of an Elderlaw attorney, with a spousal situation, we can many times save almost all the assets. May have to change form, like Kelly said, the lake house may not still be a lake house. With a single person, we may, and we usually and typically can, save at least half the assets. That's not all of them, but you're late to the game. So we try to do the best we can under the law. And we just try to follow the law. We never hide things. It's not a game. We just follow the regulations as they exist. But for each family, the situation is different. And the earlier we can get involved, the more that we can do. Particularly for those who suffer from Alzheimer's or have a loved one suffering from Alzheimer's, we're going to be going through this whole entire journey that we've taken you on with the lecture. We're going to start out with legal documents. We're going to look at what they need, make sure we have what we need in place. We're going to maybe be going through the world of VA as we progress through home care and as we progress step through assisted living and maybe memory care that's unskilled. And ultimately, we need to be prepared for the possibility that a nursing home may be needed. Everybody, if you ask them, every person who comes in our office who is in a more of a pre-planning or early diagnosis situation is never going to put their loved one in a nursing home. How often? It's never going to happen. It's never going to happen. And you don't want to stomp on their optimism, but we are very practical, and there are just times when that decision gets taken away from us because of safety concerns, because of the toll caregiving takes on the caregiver. Sometimes we lose that person, or they become too unhealthy to sustain that level of work and dedication. And sometimes it's just illness, just generally, or we have sundowners, they wander, or they are leaving things on the stove. There's just a million things that happen. So what we're going to look at now in our last bit of time here, and Kelly, you can come on up with me, I think, if we want to kind of flip through them together. We have a couple scenarios that we thought would be nice to work with, just to kind of go through and show you how these things all fit together. So scenario one, we got Mr. and Mrs. Smith, typical middle-class Kentucky couple in their 70s. He worked at GE, and she was a homemaker. They have significant assets that they've accumulated over their lifetime, plus their home and cars. But now Mrs. Smith has received a diagnosis. She has Alzheimer's disease. Mr. Smith just doesn't really know what he needs to do, what he should do, but their children have said, let's get an attorney involved. So in that situation, we're going to look and see what we think would be the right thing. So we know that there are a couple of things that, pieces of information that are missing. We don't know yet that if Mr. Smith ever served in the military, so if he was a veteran. I do that all the time. I've been yelled at by a couple of lady veterans who think I'm sexist. And I may be, I don't know, I keep thinking. Is either one of them served in the military. So that might be something that we could be looking toward and seeing what we need to do. We're going to also be looking for Medicaid as an issue down the road. So we're going to look and see what tools might we use. There are some Medicaid compliant annuities we can use that are very specialized. These are not the kind you would receive a sales pitch at your bank about this type of product. It's not a money maker, it's a money preserver. So that would allow us to use some of those and maybe be able to save some assets. And we can delay doing that kind of planning somewhat until the time that Medicaid is actually needed, so skills care is needed. But in the meantime, we're going to look and see about getting that extra money. Now, we can't get $2,100 for them because Mr. Smith is not the one who needs the care. So they're going to be at a different level. They're going to be at the lower pension level. But we're looking at $1,400 a month we could give those that would help them pay for home care, bring in somebody, give him some breaks in his caregiving for her as her condition may get more intensive. And then, of course, they may have to fund those middle areas of care with their resources until Medicaid becomes a player. If he has no veteran status or she has no veteran status, then that may not be a possibility. There are insurance policies, and we haven't covered this. Long-term care insurance is something that I will tell you we all recommend. So if you're young enough and healthy enough to get it, we recommend it. It is a good product. There are new products out there that will allow you to buy a life insurance policy with a rider for long-term care, so you don't have that use it or lose it fear that people used to have with long-term care insurance. I can't promise you the premiums will ever be cheap on these kinds of products, but I can promise you nursing homes will always be expensive. So that is my advice to you. So if you have the funds, it's a thing that you can use it with good Elderlaw planning. The two, hand in hand, very nice partner. We can really do good work for you. That gives us one more tool in our toolbox. And I'll let you use
All right, so this is Mr. and Mrs. Jones. They're in their 80s. Mr. Jones was diagnosed at least 10 years ago, it sounds like, with Alzheimer's. Throughout their married lives, he handled all the money, and now he can't really do that. So they have savings of $285,000. Since he can't do it, Mrs. Jones is trying to do it, but she doesn't really know what she should be doing. He used to be still able to participate, but now he isn't. let's see, Mrs. Jones never thought of adding herself to the account that has this $285,000 in it. It's only in Mr. Jones's name. And Mr. Jones can no longer sign checks or any legal documents. Now she's contacted us. So it says that he can no longer sign checks or any legal documents. I don't know what that means. Does that mean he physically does not have the ability to sign the check, or that he's not competent? We're going to do an analysis. We're going to do an assessment of whether we think he's legally competent to sign documents. Sometimes they're not. I mean, I just have to say, we're past that point of no return. It's a terrible place to have to be. We did some training with an attorney in Tennessee, and I'll never forget, he said, we all know everybody's competent to sign their power of attorney and other legal documents. And Misty and I looked at each other and said, no, we don't know that. You know, there are many times when we say, we just can't do this. I'm sorry, we can't help you in that way. So that's the first thing that we're going to do. Yes, sir?
Who makes the determination, the doctor or the attorney?
Well, in this case, because what we're looking at is legal capacity, we're going to have the attorney make the decision. Now, I'll say this, if there's a neuropsychologist report in front of me that says this man can't make any decisions for himself, I'm most likely not going to make a determination that he can't sign those documents, right? I'm just asking for a fight if I do that. So we're just going to see where they are in the disease. The point is, just because you have a diagnosis doesn't necessarily mean you can't still do documents, but sooner rather than later is what we're looking for there.
The standard, just so you know too, like the standard in Kentucky to do a will is what's called a lucid interval standard. So you have to know what you're doing when you do it, but you don't have to remember it. So that's your standard for Kentucky. So it's called lucid interval doctrine.
It's as low a threshold as it sounds like.
It is what it sounds. So people will say, well, I've got the dog numbers, and things like, she may be able to. And maybe she can do it at 10 a.m., but she can't at 5 p.m. because her competency or capacity may be very different at different times of the day. If you're familiar with people who are battling with this disease, it is very fluid. Or if she's sick with a urinary tract infection, you may lose weeks of capacity, and yet once recovered, she has capacity again. Right. So for power of attorney, they have to have the ability to contract. So understand that they're giving the ability to handle finances to another person, who that person is, and they have to be able to reach that mutual understanding. And then you've got your lucid interval as the standard for the will itself. So,
you know, I have a client, I met with them again yesterday. It's an early onset dementia case, which all dementia cases are sad. Early onsets are really tearjerkers for me. She's in her early 50s and has had the diagnosis for probably about 4 years now, and she no longer knows her husband of 20 years, and she calls him granddad. She doesn't look in the mirror to know that they both aged, but that's just who he is to her now. So, you know, I told them yesterday, fortunately I've been working with them for a number of years. She did know him. We were able to get documents in place. But they asked about possibly changing the will. Her children were in on this appointment. And I said, no, at this point we did not do that. We did what we needed to do before anyway, but they just wanted to know. So, okay, if he's not competent, that's when we find that we go to guardianship. So she cannot, if she's not on that account and doesn't have a power of attorney to act for him, she cannot take those funds out of that account. She cannot use those funds. So we're going to have to get an order from the court that would allow her to do that. Once we go to court, the court is going to supervise every dime that is spent out of that account. So if we're going to try to do asset preservation, we've got to get the court to say that that's okay. So we want her to keep the money rather than spending it all on his care, because she may need assisted living 3 years from now. We don't know. And there's no Medicaid or anything else to pay for that in Kentucky. So we want to preserve those assets. The court's got to approve that. We don't know if the judge is going to do that or not. We just don't know. Some cases, we've been successful in cases, but there's never any guarantee of that. We definitely want Mrs. Jones to put the assets in her name if the court will allow that, because if we do go and apply for Medicaid, he cannot have more than $2,000. Medicaid will give us some time to get it out of his name, but after 6 months they say, you know, no, we're going to kick him off. So 3, Ms. Lawson, she's single, unmarried, 69-year-old. Her family received reports from neighbors that she's been roaming, she's been wandering, talking to strangers and inviting them into her house. Her nephew was concerned and took her to see his family doctor, and the family doctor said, sounds like dementia to me. Over her lifetime, Ms. Lawson had an estate of $60,000. She doesn't have a will or any legal documents. But she did tell her nephew one time that she didn't want any life support if she lost her ability to make decisions. The nephew took her in and spent all her savings. All right, so look at
Want a
this.
new car?
Well, that's what I don't know. I don't know. He spent all her savings. Very well could be on her care. That's what I'm hoping. He sounds like a good nephew. So that's what we're hoping. But, yeah, but if he didn't, if he really misappropriated her funds, used them for his own, for himself, then what we would need to do is she needs to go into the nursing home and apply for Medicaid. Medicaid's going to say, well, unless you pursue charges against him, we're going to treat that as one of these transfers that Misty talked about. That's $60,000. Divide that by 6,000, 10 months. That she would have to pay $8,500 a month, and I guarantee you her income is nowhere near that. For her nursing home care. And the nursing home can't discharge her for not paying. By federal law, they can discharge her. They have to find somewhere for her to go, but where's going to accept her if she doesn't have the ability to pay herself or through Medicaid? Okay, now, if they know, the neighbors or anyone else, if you know that an elderly person is being taken advantage of, you are required by law to report that. Kentucky is a mandatory reporting state. We have adult protective services that investigates that. We have in Louisville a crimes against senior unit with the police department that will also investigate that. But you have to report it if you suspect it, if you have a reasonable suspicion of any type of financial exploitation, physical abuse, or neglect. Also of self-abuse or neglect. So if you see an elderly person and she's not taking care of herself, and it's because you believe she doesn't understand what needs to be done to take care of herself, you're also required to report that. If she truly doesn't own anything when she dies, then she wouldn't need a will, but she might still need someone to act on her behalf and tell creditors about that. So, maybe the nephew really didn't spend the money on her, and it'll be okay to handle that type of activity as well. The living will, I didn't put this on here, but since the fact scenario said, it's like being in law school again, thanks a lot, guys. Since the fact scenario said she had told her nephew that she didn't want life supports, well, the doctor, like we mentioned before, if there's no healthcare surrogate in place, is going to look for family members, guardian first, power of attorney, spouse, etc. So if he is the closest living relative, then he could convey her wishes, and the doctor should listen to that.
So the last scenario that we have for you is Bob and Alex. They're longtime roommates in their 70s. They've never really acknowledged or been out as far as being a gay couple or committed to each other, but that's the situation we're assuming is here. Bob has been recently diagnosed with Alzheimer's disease, and Alex is finding himself in a very difficult position because caring for him without having that spousal presumption, where is that going to leave him? Bob's family wants to take him away, put him in a nursing home somewhere, and Alex is trying to find a way to keep Bob with them. Their assets are $1.2 million, so considerable together. Fully paid home, jointly held with rights of survivorship. Bob's brothers and sisters, they've heard about that money, and that house is nice, and so they are trying to get involved and get their hands on it as well. And Bob never really thought about preparing a will, because if you do that, I heard that you die. If you write a will, we're all going to die, so everyone's will. I used to tell people, and if you die, and I was like, I have to stop that. When you die, we're all going to die. But he did do a power of attorney, so he did name Alex as his attorney in fact. So this one has a lot of issues involved, because to be honest, it is an evolving area. Because there was a time when a couple such as Bob and Alex would come to our office and we would say, this is a really bad situation for you, unfortunately, because our programs in state and federal are going to treat you both as single people. No matter your status, no longer your length of devotion or care for one another, you'll both be single. And as we saw, for example, in the Medicaid system, there's a big difference between being single and being married. Because being married, you have that, at least some element of asset preservation built in. The home, the car, all those things. And that wasn't true of a single person. It has to be sold, it has to be spent. Now, it is the belief of our national organizations that we belong to, that activists in this area, particularly where the two meet, with Elderlaw, that the federal government will require all participants in the Medicaid program to treat a couple such as Bob and Alex, if they are validly married in a state that recognizes gay marriage, to be treated as a married couple. So that would take on another presumption here, that they went to New York and had a great weekend, all the best friends were there, and they had a great wedding, right? Because if they just lived together here in Kentucky, it wouldn't necessarily work to get that protection. So we do look at each asset. So as far as the home, we do know that is it to say Bob and one that's in the nursing home, right, are going to be in care. Alex is going to get the home when Bob passes away, because that's joint provider survivorship, so that's going to go to him without any interference. The sisters and the other relatives, they're just going to have no rights against protesting that. That is going to be protected. But everything else, since he didn't have a will, is going to go to his heirs at law, and that is not going to be to his partner. So unless he's made arrangements, that's not going to happen. It doesn't really matter the nature of their relationship. And I don't know that there's any indication, and Kelly, you can tell me your thoughts on this too, because that's not federally based. That's not going to change even if they were validly married in New York. So these rights of dower and courtesy are rights in the spouse's estate. While that may be true for federal taxation, for federal estate tax, I don't think that it is presumed that that would apply to a state succession or intestate inheritance. I don't know, Kelly, if you have any other thoughts on that.
I really hadn't thought about that, but I guess very well could be right.
So we'll have to see how it all shakes out. So we'll have to kind of take a look. What we do is just try to plan with those couples that are in those kinds of relationships. We just try to plan so that no matter what the law says, it's going to go where they want it to go ultimately. Yeah, write your will, write your law. On the healthcare decision, the power of attorney document that does have healthcare language, as long as it has that, he's going to be higher on the chart with the sibling. So he is at least going to be able to make some healthcare decisions. And he's even going to be able to handle most things. Our problem we found is that when there's a lot of fighting, many times the medical professionals kind of throw up their hands and say, you all need to go to guardianship court. And then once we get into guardianship court, it's really going to be up to a judge who's going to be making these decisions and what exactly is going to be happening. Our thoughts on this was we want this couple in to see us early, so that we can make sure that we take care of all these different issues. But we have kind of laid everything out there for you, kind of our thoughts on each of these scenarios. One thing I wanted to add that I don't think we brought up earlier is that the age of your legal documents does make a difference. A will, on one hand, may be good for many, many, many years. And as long as it's self-proving, so notarized, it's got all the right valid, all the things required to be valid, as long as it still says what you want it to say, and it's a wise decision, we're still leaving it to our spouse, is that the right thing? It could last many years. Power of attorney documents are different. It is dependent on the bank, the insurance company, the brokerage house, whether they choose to accept it. And their position right now is that once they are older than 8 to 10 years, they do not want to take them. Because they're worried they are no longer valid. There's a newer document out there, and they don't want to be sued when somebody takes all your money, and you say, how would you take that 15-year-old power of attorney? You should have known better. So even if you have one, we want you to make sure you take it out and look at it. And we didn't bring it with us. We have a great checklist. If anybody wants to contact us, our emails are on there. We can send you to let you look at your documents and see whether or not you think they're up to date and kind of have all the elements that we discussed.
Oh. Oh.